Today we have I have to discuss about the international conflict resolutions, the development and implementations of peaceful strategies for settling conflicts using alternative to violent forms of language are known by the general term conflict resolutions. It was argued by Goldstein 2003. Goldstein. Conflict resolution mechanisms are not new. We know the Charter of the United Nations lists some methods by which conflict can be resolved between states. Article 51 lists methods for peaceful settlement of disputes between states states by used by following tools we can resolve international conflict. Negotiation. Through negotiations war could be resolved. It was happened much of time in the world by John Galtung and many other peace practitioners. Resolve the conflict. Mediation. Mediation is an extension and continuation of peaceful conflict management. Mediation is a non-coercive, non-violent, and ultimately non-binding forms of intervention. Mediators enter conflict whether internal or interminal in order to affect it, change it, modify it in some way. Violent option in the war sometimes occur very much problematic situations. Then we should apply these tools for peace set up by international organizations. In the Charter of United Nations, Article 33, the United Nations investigates almost all the peaceful ways of resolving international conflict. Diplomatic and political methods. Diplomatic and political methods do not use force and violence, and final judgment arrived through these mechanisms may not be binding upon the parties concerned. Hence, they are called non-binding and non-decisional, and mutual agreements one generally arrive at through compromise. These methods are negotiations, good offices, mediations, inquiry, conciliations. Next, judicial. Judicial methods are also peaceful, but the only difference between diplomatic and these methods is of its binding nature. The decisions arrived through these methods are binding on the disputed parties. Hence, this process are described as decisional and binding. To judicial methods are arbitrations adopted by PCIJ and to adjudication adopted by ICJ, International Court of Justice. Next, coercive methods, sort of war. It states turn to coercive but non-violent methods for the resolutions of conflicts only if peaceful procedures fail to produce the desired results. Most of these devices, although expressed in the mechanisms of the diplomatic process, have their ultimate coercive effect in the psychological realm. These non-violent coercive techniques may be pursued through numerous state actors in the form of recall of diplomats, expulsion of diplomats, is forced to leave. Expulsions means is forced to leave. Denial of recognitions. Denial means a statement. It is not true. Rupture diplomatic ties. Suspicion of treaties. Rupture means the break or split. These actions are taken by adopting one of the following methods: reprisal by the punishment, retortion, embargo, boycott, blockade, intervention, and collective security. And next, coercive method through war. Last resort to the resolutions of conflicts in the international system has always been the organized application of violence in the form of war, but the war may either be fought by tacit agreement within the terms of reference and restraint laid down by the international system and thus be related to the controlling equilibrium, or it may potentially be destructive of the system by threatening to alter relationship drastically, dysfunctionally, and permanently. Consequently, wars can be fought into broad categories: limited war and total war. Next, arms control and disarmament agreements. Above are the discussions of conflict resolution tools. Thank you for watching.